Hello and welcome to Rights and Recourse, a program that educates you about your rights and recourse to those violated. My name is Dumila Matez. Customary family law is an essence of customary law, and family relationships are of fundamental importance as far as customary law is concerned. The traditional customary family law has been drastically amended by the recognition of Customary Marriages Act. The Act, however, requires that the customary marriage has to be negotiated, entered into, or celebrated in accordance with customary law. Marriage traditionally is a matter between two family groups and not merely a bond between two parties. Prior to the Act's customary law, or customary marriages, better known as customary unions, did not enjoy the same status as civil marriages in terms of the Marriages Act No. 25 of 1961. In many rural homesteads, the issue pertaining to the registration of these marriages is often overlooked, largely due to the ignorance of the provisions of the Act or the subordinate position of the family partner. Today on Rights and Recourse, we examine this phenomenon and its impact, in essence, in issues of inheritance when there's a dispute. To discuss this issue, Advocate Moses Malakate, Senior Legal Administrative Officer from the Department of Home Affairs, Mr. Stembi Somabaso, Associate Lecturer and Attorney at the Wits Law Clinic, Mr. Sani Nameng, Director of KNT Incorporated. Gentlemen, good afternoon and welcome to Rights and Recourse. But before we get into our discussion, let us have a look at this insert.
It's a brand new day, and so it's a new chapter in the life of Zandile Mbata. This is a day of celebration for the community of Eshowe. In the Zulu custom, a wedding is a public event. No formal invitations, the news are spread by word of mouth.
Ngibona sengathi lubalulekile ukwenza izinto ezifana nalezi ikakhulukazi kubantu abasebasha njengathi nalabo abancane abasuke bengakafinyeleli eindaweni zokuthi nabo baze bafinyelele ekutheni bashada ukuthi babone ukuthi mase beshada ngakusasa usiko lwabo indlela kukhomba nendlela ukuthi kufanele sibheke ngaphi.
Mbongeni Biela is only 26 years old, but already expected to be the next chief in the Biela clan. And the journey to his homestead in Enkandla is the final long-awaited stage of a long process as preparations begin way in advance. Like the Western tradition, the groom is not allowed to see the bride before their union is formalized. The cattle play a very important role in bringing the couple together, starting from ilobola to the bride leaving her household to her new life. On the other hand, this ornate box, while bearing a whole lot of gifts for the in-laws, also carries with it an even deeper significance.
Yabona leli abhokisi lifana noma iba uyemoshal ukhiphe isitumbu emoshal sifake ebhokisini ustart usise emangcwabeni akuthi manje uphelile lo muntu ekhaya usuwe emangcwabeni uyongcwatshwa leli bhokisi njengoba yogana uyathathwa lapha leli bhokisi uza nalo lapha useyobizwa ngesibongo salapha lapha eyoshada khona ushana nomuntu ofileyo manje kubo uthathwe naleli bhokisi walethwa la imabe xabana behlukana nendoda yakhe ngeke alithathe leli bhokisi yolishiya lapha ekhaya leli bhokisi ngoba kwaphuma inkomo ziyomthenga kweza leli bhokisi.
The jovial competition between the two sides lasts throughout the whole day, building up to the highlight of the event. After a local induna has led the couple in their vows, men appointed from both sides of the family will give praise to the ancestors as everyone remains quiet in respect for the ritual. The wedding ceremony ends with the bride giving gifts in the form of blankets to her new family, including the extended family.
If you'd like to join us in today's discussion, please call us on 714-5497 or 5498, 011-714-5497 or 5498, or tweet us on Rights Recourse. We'll be back after the break.
Thanks, Mom. Have fun. You too.
Purchase an Audi A4 with Xenon lights for only $3,899 per month and receive a complimentary 20,000 kilometer extension to your Audi freeway plan.
This former breadbasket of Africa, playing host to SADC leaders.
I feel humbled and yet greatly honored at being appointed the chairman of SADC.
When I was a student, Harvard was only my visible college, my formal classes. But I was also a student in an invisible college.
The outbreak in West Africa is the world's deadliest to date. It's centered on Guinea, Liberia, and Sierra Leone, with cases also reported in Nigeria.
Catch news at 8, 7 days a week. Be informed.
Welcome back. Gentlemen, there was a truly traditional or customary marriage taking place in that insert. Is that what we know about customary marriages?
Well, I would say it's part of the celebration of the customary marriage. It's one of the processes that are required in terms of concluding the customary marriage. Then that's one of those processes.
Mr. Malakate, we have a liberal constitution. And why did we have to go back and recognize customary marriages when we have a liberal constitution? Or does the constitution allow for us to recognize customary marriages?
It does. We had to go back because simply the constitution was just to put in a framework of how the government or how the country should be run. But then you have these other pieces of legislation that have to conform to the constitution. Hence, we needed to go back and recognize marriages that are entered into and concluded following customary customs. That's the best answer that one would give in that situation.
With all the negative connotation that the customary marriages have, where the wife is subordinate to the male partner.
Well, look, with the advent of the Constitution and the recognition of Customary Marriages Act, we've gone a long way from moving away from those practices. For instance, in terms of the recognition of Customary Marriages Act, now a female spouse in a customary marriage has equal status and capacity as the husband, which means she can be sued in her own capacity. We need to remember that any law that we have in this country needs to be in line with the Constitution. So going back to your initial question, I don't view it as going back and recognizing our customary marriages or customary practices, but I think the Constitution itself is aware of the diversity of our country, and it gives effect to that. And therefore, we need to have laws which regulate what we do in our own customary practices as well.
Initially, customary law was not recognized by the old laws that we had under apartheid. And only now, with this constitution, are they recognized. Why were they not recognized?
Well, I would say it was to a certain extent recognized in terms of the Marriage Act of 1961, but with limitations. However, with the new dispensation, and looking back at the apartheid system and to rectify what happened previously, the new act was introduced to be in line with the Constitution. Because if you look at Section 39, subsection 2 of the Constitution, it's quite clear that for each and every law that you need to interpret, you have to look at the Bill of Rights. And recognition of Customary Marriages Act was also introduced to also protect the basic rights of indigenous people.
I just want to go back to something, unless you wanted to say something, Mr. Malagate.
Yeah, and also they were recognized. If you look at the Black Administration Act, that was the law that was meant specifically to deal with customary marriages at that time.
Separate from the Mainstream Act.
Of course.
I want to go back to something you mentioned earlier, that the wife can sue. If you are staying at my homestead in the rural areas and you sue me, I will chase you out of my house.
Well, unfortunately, that sort of unequal bargaining power still exists. But insofar as the legislative framework is concerned, the legislature has made a gallant effort or attempt to give females equal status to that of their husbands. And that's in line with our Bill of Rights. And it's now an issue of more awareness of people's rights and taking action. If should you throw your wife out of the house, I mean, she's got recourse in law, which she did not have previously.
The one thing that I wanted to ask here, we all know that ukutwala is a repugnant way of taking a wife, of taking a wife for yourself. But there are cases where ukutwala people have then settled and became husband and wife. Can that be regarded as customary marriage in the end?
For as long as the marriage is then concluded following the prescripts of the law, it could be recognized. And it could be registered as a customary marriage.
So basically, as long as the marriage complies with the requirements as set out in Section 3 of the Recognition Act, the marriage is then valid.
The Act came into effect in 2000. Can people who got married in a customary marriage before the Act came into effect, are they recognized by the Act?
Yes.
Yes, they are due recognized by the Act. They have to register that marriage within a period of 12 months after immediately after the Act. Indeed, they are.
Yeah.
That marriages are recognized.
What happened was when the Act came into effect in 2000, it specifically stated at Section 4 that it's got retrospective effect. So people who entered into customary marriages which were valid before 2000, they must just approach the Department of Home Affairs for registration of the customary marriages. A period of 12 months was stipulated in the Act. When the 12 months elapsed, that period was later extended by the Minister
of Home Affairs.
Yeah, and then but now we find ourselves in a very difficult position because you have people who entered into customary marriages before the Act came into effect in 2000, and that period, the 12-month period, hasn't been extended again. So now people who find themselves in that situation will have to approach the courts for recognition and registration of their marriages.
Quickly, Advocate Malagate, apparently there have been people who have been married for years under customary marriages in the rural areas. Do you mean those people are not covered if they are only given, if marriages take place within 12 months, that marriage must be registered?
registration does not affect the validity of the marriage. The marriage will still be there, but it just creates a bit of a difficulty when you come to other situations. For instance, your inheritances, in the event that one of the spouses passes on, then it creates a bit of a situation, because then the other person does not necessarily have the rights as accorded to a person who has registered the customary marriage.
Well, when we come back, we'll touch on why necessarily was this act promulgated. If you'd like to join us on today's discussion, please call us on 011 714 5497 or 5498, or tweet us at Rights Recourse. We'll be back after the break.
SABC News delivers stories
that unify the nation
in many ways. Stories that inspire us to see the world differently, appreciate and celebrate our diversity. And mostly, they make this place a better country to live in despite our color, beliefs or culture.
I
am
Mahendra Raghunath.
Tabile Ngwado, Lulu Gabu.
Join us every day
as we provide updates on local and international news straight into your home. We are
SABC News. An American-based foundation has donated 15 million rand for the construction of a clinic at Umlazi.
This facility that is going to be built here with a 15 million rand contribution from AHF is, among other things, going to actually help us to expand.
Itembaletu Clinic is the only clinic that caters solely for HIV patients. It accommodates 16,000 people.
Your world, weekdays between 11 and 12 midnight.
Welcome back. Gentlemen, the one thing I wanted to know, if we have a constitution that regards everybody as equal, why then did we need an act for these marriages to be registered so that they can be equal? What is the act guarding against?
Within the constitution itself, it recognizes the fact that the diversity that Mr. Mavaso spoke about. And within that, it then gives, goes as far as to say, we need to recognize and we need to give effect to the rights of people who belong or who believe in customs. So embedded in the Constitution, there's a provision that deals specifically with giving effect to the rights of people.
So in a nutshell, if I were to say why the Act came into effect, it's to make provision for the recognition of customary marriages, to specify the requirements for the registration of such customary marriages, more importantly, giving equal status and capacity to spouses in a customary marriage, and also to deal with the proprietary consequences of customary marriages.
Probably you should explain this proprietary consequences. Is this had to do with inheritance and those kind of things? Should
the property of the spouses.
The property of the spouses.
So what is the matrimonial property regime? Are customary marriages regarded as being in community of property or out of community of property? What happens if it is a polygamous marriage? If the husband has more than one wife, what happens with the property of his property and that of the spouses? So the Act makes provision for all of that and clarifies it.
How then do women in rural areas know about the Act? Whose responsibility it is to explain to the people in rural areas that there is an Act that protects you against this and that, against being thrown out of the house by the children if you married somebody with children. And when that person dies, you are thrown out of the house by the children. What recourse do you have? Who does that? Who does that?
You see, a person who does not know his rights is like a person who does not have rights at all. Unfortunately, I would say the government is overworked, but it is a responsibility of the government to ensure that information goes to people. So as it is, you will find Home Affairs in local areas, and I assume that each and every person who concludes a marriage would know that he would go to either the magistrate court or the Home Affairs. And if it's a customary marriage, I suppose the Home Affairs have appointed officials other than your magistrate and other officials other than the ones that have been appointed. I think the chiefs and so forth, or people to administer those marriages, if I'm not mistaken. There is that.
Let me see, we've got somebody from Home Affairs. Is that the case?
No. Not like that. But what Department of Home Affairs has done is to say there are people within the department at offices, at our offices, that are then appointed as registering officers. So what they do is, it's when a person comes in or when the spouses comes in, they were able to register the marriage and issue that the spouses with a certificate. However, also the Commission on Gender Equality, it's also tasked in terms of making our people aware of the rights related to customary marriages. So it's more of an awareness campaign that needs to be done for people to understand what the act.
There is no enforcement.
There is no enforcement.
How then does this act work if there's no enforcement?
Enforcement in terms of the awareness, or enforcement in terms of the act?
Enforcement in terms of the act, because the act says everybody must be recognized, the marriage must be recognized. And I heard you making reference to traditional leaders earlier, traditional chiefs. What if the traditional chiefs in our patriarchal society in which we live in does not believe in what we are and what the act says?
Well, I mean, then even their conduct or decisions that they make have to be in line with the law. So with the supreme law of the land, which is the Constitution, and any other legislation that flows from that. And insofar as enforcement is concerned, the Act does make provision for enforcement of customary marriages. And by enforcement, I would say it's through the recognition of these marriages that we get enforcement. Section 4 of the Act is very clear on that. It prescribes the way in which your marriage can be registered. For instance, if parties enter into a marriage today, they have 3 months within which to approach Advocate Malekane and have their marriages registered. Failure to do so does not render their marriage invalid. They can still approach the court for recognition of their marriages.
I came across, I don't want you to say something, Advocate Malekane, but I came across a couple of things in my research. One was the Transkei Act of 1978, the Dual Marriages Act, and the other one was a Codes of KwaZulu-Natal Code of Law. Probably you can explain what happened to those and what did this act, with the coming in of this act, did those become null and void?
Not necessarily. Not necessarily, because you would find a situation where somebody was married following the prescripts of the Zulu Code. So when you are dealing with that type of marriage, you would then, in terms of the proprietary rights that Mr. Mavaso spoke about, you would then need to look at that piece of legislation to see what is it that it was saying. But however, post 1998, when the Recognition of Customary Marriages Act came into effect, it then says that all the marriages that are concluded after, they have to follow the prescripts of this legislation. But those ones are still there.
So now the question is, what's the position with the marriages
yes.
which were entered into prior to coming into effect of the Act? They're still valid. If they were valid in terms of whatever prescripts were prescribed before the Act came into effect, they will be valid. But there's a difference with regards to the proprietary consequences, because With marriages which were entered into before the Act came into effect, the proprietary consequences are in terms of the customary law. But marriages entered into after the Act came into effect are deemed to be in community of property, obviously unless there's an anti-nuptial contract which says otherwise. So that is the difference between your marriages which were entered into before the Act came into effect and the ones which were entered into subsequently.
For the benefit of our viewers, could you just explain, earlier you did explain what the relationship between the Transcar Dual Marriages Act and this Act is? I think there's some little difference. In terms of, in the Transcar Dual Marriages Act, if you had previously married taken a civil marriage, you can follow that up with a customary marriage.
Well, with the Recognition of Customary Marriages Act, it works differently. The Act makes provision for parties who are married in terms of the Act or in terms of customary law to enter into a civil, what's commonly referred to as a civil marriage, but it does not work vice versa. So once parties have entered into a customary marriage, they can later on enter into a civil marriage for whatever reason that they please, but they cannot do it the other way around. So if you've entered into a civil marriage first, you cannot then enter into a subsequent customary marriage.
Even if you take somebody else as your wife?
You can't take somebody else.
You cannot.
You cannot. It goes back to the issue of adultery.
Yeah. No, I mean, if I take another wife, but I take this wife under the Customary Marriages Act, can I do that?
You're taking both on under the customary marriage?
No, the one is a civil marriage, but I just want the other one to be under customary marriages. I don't want necessarily to go and make a big party. I want to make a small thing for the family members.
But that will constitute bigamy. Because you are already married in terms of the
But
civil
the Constitution recognizes polygamy.
It recognizes polygamy in the context of customary marriages. So
Exactly.
if you've been married under the Marriages Act, you cannot marry another wife. So the question in that instance, in that hypothetical situation, is which marriage came first? If the civil marriage came first, that's it. You cannot marry anyone else. But if you enter into a customary marriage, you may very well enter into subsequent marriages in terms of customary law, though. They cannot be converted into civil marriages.
If I'm right, the Act does not prescribe issues like lobola, those things, but it does talk about negotiations. What does it mean?
One of the requirements in terms of Section 3 of the Act is that there must have been a negotiation. So that would be the negotiation for lobola. The Act does not specifically say that there should be payment of lobola, but the issue has been dealt with by the Constitutional Court, where it said that when looking at customary marriages, we need to observe the customs, usages, and practices of that culture, of that particular group of people. So if actual payment of lobola is a requirement for validity of a customary marriage in SABC, then it has to be paid, although the Act does not specifically say so.
In case of a dispute, does it ever come up that lobola was never paid, therefore this marriage cannot be valid?
Like Mr. Mavasa is saying, the actual payment of lobola is not a requirement. What needs to have happened is that the families, in terms of custom, they have met, they have negotiated lobola, they have entered into an agreement to say lobola will be paid and so much will be paid. But does not necessarily go to an extent of saying actual payment should have been done.
But I could use that as a defense. If I was litigating such an issue, I would use it as a defense if the customs and usages of that culture prescribe that lobola must be paid. That, in my opinion, that is a valid defense. Because
well, we will come back and round up on the issue of lobola when we come back and continue with the discussion. If you'd like to join us, you can join us on this discussion on 011 714 5497 or 5498, or tweet us at Recourse. We'll be back after the break.
Zoom into Africa. This is Sierra Leone. The president is Mr. Ernest Bai Koroma. Sierra Leone got independent from the United Kingdom on 27 April in 1961. The population is more than 6 million people. One of the major languages spoken is English. Monetary unit is Leone.
Africa is growing at a rapid rate.
A huge part of this African growth is technological innovation.
Like a group of students hard at work in Uganda developing tools that will save lives. Or an African-developed payment method making the public transport industry cashless in Kenya.
You book me through M-Pesa.
There are apps only for people who live here. And the continent is accepting the growth of modern technology usage in people's everyday lives.
The ICT revolution now belongs to Africa.
This is information that matters to us.
To find out a bit more about social media and technology news, join Ms. Phumelele Zondi every Sunday at 7:30 p.m.
Well, welcome back to Rights and Recourse as we discuss customary marriages here with these esteemed gentlemen with me here. Gentlemen, one thing I wanted to conclude quickly around that issue of lobola. Amongst the courses normally say, lobola aigqitwa, you don't finish paying lobola.
I would say it's a practice, but that does not necessarily mean the marriage itself, customary marriage, it's invalid. The Act is very clear. It makes requirements.
We can finalize this thing when we come back. Let's just talk to this caller here. Anonymous, good afternoon and welcome to Rights and Recourse.
Good afternoon, ninjani bo baba?
Sikhona kunjani?
Sikhona. Baba mphathi wehlelo. Mina ngimdala lana ngine 70 years. Manje lezi zintweni zikhuluma lapho. Ingathi nje zinokudidanisa. Manje kune-fat and set phakathi kwaleyo nto. Manje i-fat and set asivumeli. Akuqalwe kuyiwe amakhayeni amabili wezihlobo ezivanayo ukuthathana ngokomtshado. Kuqalwa ekhaya khabontombezana. Umfana uqala kumalume. Bakhiphe ilobola. Abafuni umshado lo wesilungu, mara bafuna ukuthathana. Beqedile amalobolo sibhalile sisayinile thina ama-negotiators bangahamba bayenzelwe umcimbi kuthiwa so kuyinkosikazi lapha bacela ke unkosikazi yabo laba abekhipha ulobola uma beshotha bazothi siyashotha sayohatha masika ritabuya mara rikopela musrati.
The lady is saying she's 70 years old. We are a little bit confusing her with the Act. She knows there is cohabitation. And in that cohabitation, then they encourage the pairs to go and negotiate with the families, and the families agree, and lobola is played. But the Act doesn't say anything about cohabitation.
No, it doesn't. And cohabitation does not give spousal rights. What gives spousal rights is if the parties or the prospective spouses have agreed that they want to enter into a marriage in terms of customary law, then they would have followed all the processes and all the that are required in terms of that particular custom. Once that has been done, they can then come and register the marriage.
Correct me if I'm wrong. I'll come back to what you were talking about earlier before the caller came in. Correct me if I'm wrong. There is a place in law that says if you had been cohabitating with somebody over a period of time, and when it comes to proprietary rights, the person with whom you have been cohabitating has rights to your property.
Not necessarily.
Not necessarily.
Like Mr. Advocate Nameng said, there's this misconception that through cohabitation, people gain some spousal privileges as though they had been married, and that is not correct. That is not correct.
Earlier we finalized, I don't, Mr. Advocate Nameng, Advocate Malakate.
What would have happened if we have cohabited, say, for a number of years, and we are both contributing to the common, commonly within the house. Say, for instance, we buy a house together, you buy a car together. Then you would say, because I have contributed to that, then I'm then entitled to half of that. But it does not necessarily mean that at the end of the marriage, at the end of the cohabitation, that one would have spousal rights or to the property.
I would say it goes back to the law of partnership and civil law. The party who feels aggrieved by the circumstances will have to approach the court on the basis of civil law, not necessarily in terms of the Divorce Act or customary law. That I have contributed to this partnership, and I am entitled to my contribution in respect of the partnership, but not because of the cohabitation, because cohabitation, that is the Fatense thing, is completely out. It cannot actually legalize or validate a customary marriage.
The Act does not interrogate, the registration officer does not interrogate the two parties as to whether lobola was played or negotiations did take place, even though the law stipulates that there must be negotiations.
Well, in terms of registering, we do require that there must be a copy of the lobola agreement. So when the parties come to register the marriage, as part of the documents that should be there, it will be a lobola agreement.
And you can also include affidavits from people who witnessed the negotiations and the celebrations, because the registering officer needs to be satisfied that a valid marriage was entered into. So if you're going to approach Home Affairs for registration, you must get all your ducks in a row and have everything that you require in order to satisfy them, and that would include any letters that were exchanged in respect of lobola negotiations, affidavits from parties, people from both of the parties' families, to state that the marriage was validly entered into on this date and whatever the case is.
Well, in my view, I would say failure to pay lobola, if both parties have agreed, doesn't really becomes a requirement per se.
That's actually a question you were answering earlier.
Yes.
In other words, I don't have to pay all my lobola because there was a payment made. That marriage is valid.
What is happening is, I think we have to go back to the definition, the requirements. That is, one, both parties must be over 18 years unless there's a consent to that effect, and both parties must agree to that particular marriage. And thirdly, there should be either celebration or negotiations. One of the two, celebration or negotiations, or it can happen.
It's actually both. The Act says the marriage must have been negotiated, and there's a second leg to that requirement. The second leg being that it must have been celebrated or entered into in accordance with customary law. So the third requirement can be divided into two categories. Part one, negotiation. If that's been done, tick. Part two, was it entered into or celebrated in accordance with customary law? And that would mean whatever is required in terms of your customs and usages as Umxhosa or Umzulu, whatever the case is.
I would imagine it's not as simple as to say you're ticking boxes.
It's very complex, but going back to Anonymous's call, she pretty much dealt with one of the requirements, because the things that she mentioned are the things that are required insofar as the celebration or entering into the marriage. She mentioned going to the uncle and the uncle, his uncle's meeting with the prospective wife's family. That's the negotiation part. And then also there must still be some sort of a celebration, or the marriage must be entered into as prescribed by your culture.
So it's actually what she speaks about also is the handing over ceremony of the wife. That at some point in time, within the custom, there would have been that handing over of the wife.
Of the bride.
Of the bride
or
to
the wife.
Yeah.
But surely you are complicating an issue that is, in terms of customary law, uncomplicated. I think Mr. Mobaso spoke about affidavits and all of this. People in the rural areas can't draw affidavits. They don't understand what you're talking about.
That's the difficulty. That's the difficulty, you know. But I was just speaking from a perspective to ensure that when you approach the registering officer, they will actually register your marriage. But I would imagine that if the spouses went there together and requested that their marriage be registered, I don't know, but I would imagine that the registering officer should be satisfied, particularly if those lobola receipts can be, those lobola letters can be furnished, and you tell the registering officer exactly what was done in entering into this marriage. I suppose that should suffice.
It's actually very simple at Home Affairs.
Yes.
What for Home Affairs purposes, what you would then require is simply the identity, copies of the identity documents of the prospective spouses, and then the completion of the form, as well as the lobola agreement. Then the registering officer would then have to, I think that would satisfy the registering officer that indeed the marriage has been concluded.
You see, I'm holding a different view, because I'm looking at from this angle. Both parties have agreed, and both parties are approaches the court, the Home Affairs, and they say they want to register their marriage, and they've got confirmation that the marriage was either celebrated or negotiated, not necessarily payment of lobola. So I'm saying, because in the mere fact that lobola is not the requirement, it's not a prerequisite, that marriage can be registered. That's my view.
Because, look, the requirements are fairly simple. If you look at the requirements in terms of the Act, both parties must be above the age of 18. Both parties must consent to be married in terms of customary law. And the third one is that there must have been a negotiation and a subsequent celebration.
Can you raise your voice a bit?
Oh, sorry.
I just want to go back to something else. I know you wanted to say something, Advocate Malagate. You mentioned earlier that you need affidavits and all of these things. People in rural areas work on institutional memory, don't they?
They do.
How then do you prove?
That's why I was saying, from Home Affairs side, the affidavits, it won't be required. But what will be required, what is key, is the identity of the spouses, the fact that they have celebrated their marriage in following custom. And when you have to drill down to say what is custom, you then have to go back and to ask the question, what type of ethnicity, which ethnicity is this are these people? If they are closer, then you're looking at closer custom. What is it required in terms of closer to say marriage has been concluded between two individuals?
Well, this discussion has become a little bit more complicated, as our caller said, but please do join us in this discussion on 011 714 5497 or 5498, or tweet us at Rights Recourse. We'll be back after the break.
Platinum producer Lonman says it may be forced to restructure its Rustenburg operations. That's if its employees fail to accept the company's latest wage offer and return to work.
We are concerned about things like strike action that become disruptive and lead to job losses.
NUMSA members downed tools demanding better working conditions.
NUMSA have called upon other members to embark on secondary strike.
Your World, weekdays between 11 and 12 midnight.
The Mantango Cultural Village is a large family homestead with 16 huts, each of them with its own specific purpose.
My responsibility, it is taking care of the family. As far as cleanliness is concerned, I have to make sure that I keep the home as clean as possible every morning when I wake up.
That's Kaleidoscope, Sundays 5:30 p.m. on SABC News.
I'll come back. Let's have a look at what the people are saying on Twitter on this issue. It seems like a very hot issue here in the studio. John S. Jackson says, how can a marriage which is a contract between two consenting adults ever be the same as ukutwala? Probably with reference to what I said earlier. And Albert Mayenda said, African women must desist from expecting their spouses from dying first. And Mohale Isaac Signolo says, Interstate Succession Act will be applicable. Probably the lawyers here will pick that up. And I think that is what we have so far. But let's quickly go to the lines and speak to Tulani from Nelspruit. Tulani, good afternoon and welcome to Rights and Recourse.
Good day, sir. I'm really actually quite impressed and happy to hear this gentleman talking about customary marriage. I've got just a quick question. There's a boy that I used to know that was the only son. And the father was involved with the mother, and then the mother passed away. And then the father carried on staying with another woman. And then a few years later, this was the only boy. A few years later, and the father had assets and everything. So a few years later, the father passed away. There was customary marriage, which was in between the previous son's mother and the father. But now there is this current mother who's taken everything, and yet the brothers and everything. Does the person have a right to go in court in connection of the assets which are remaining? Because the son couldn't get anything out of all the assets. I mean, the houses, the cars, and everything.
Thank you very much. That is almost all the time the issue, that it comes down to inheritance, comes down to the issues we spoke about proprietary, and how do you deal with the situation that has just been explained by Tulani?
Firstly, it depends on the type of the marriage. If the marriage is out of community of property, with the exclusion of the accrual system, the portion of the deceased husband will be shared amongst the children in terms of the Interstate Succession Act, because now he dies without a will. Because I'm assuming we are talking about a situation whereby this person died without a will. Now, the second leg is if the parties were married in community of property and the surviving spouse, or the one that he has referred to, takes everything, that is incorrect in terms of, it's against the law. The son is entitled, in terms of Interstate Succession Act, to claim the portion of the estate. Because what happens with marriage in community of property, when you administer the estate, you apportion 50-50 in terms of the marriage in community of property, which means the husband gets his 50%, the deceased husband, and the 50% goes to the wife, the surviving spouse.
We'll continue this discussion. I just want to take this call from the Northwest. Anonymous from the Northwest. Good afternoon and welcome to Rights and Recourse.
Thank you very much. My question is based on the customary marriage. Last year, my mother and my stepfather, they went to Home Affairs to start their marriage. But what happened, my mother's ID was used by somebody else. When we were told that they must wait. Already there was an arrangement for the celebration of the marriage. Indeed, they did celebrate their marriage. And this year, February, before they could go back to Home Affairs for my mother to receive her ID, new ID, my stepfather passed away. Now the problem is, my mother, she cannot register the customary marriage at Rustenburg, as well as at Thread, because the director at both Home Affairs stated that to those people who are registering the marriages that they cannot register the marriages because they've stopped to register the customary marriages. So she's having a problem now because she cannot receive a letter of authority. She does not have a marriage certificate. She's been through to the attorney. The attorney also could not assist her. Thank you very much.
Thank you very much. We have somebody from Home Affairs here. We have advocates here. Quickly, Advocate Balakate. What Anonymous is saying, his mother was getting married to his stepfather. They went to Home Affairs. It was discovered the mother doesn't have an ID, so the marriage could not be registered. And then soon after, she got the ID. The father died. His stepfather died. So she doesn't have a marriage certificate. She can't claim anything that was associated with his father.
I suppose it's a question of just going back to Department of Home Affairs, the nearest office, and trying and find a resolution to that. But in terms of inheritances, I think if the law of interstate succession or Succession Act, there are laws that deals with that. So that inheritance will then fall within that ambit. But in terms of resolving what she is saying in terms of registering the marriage, I think she would just have to make contact with the head of office nearest to her.
But quickly, should that fail, I believe that Anonymous's mother can still approach the court for an order recognizing the customary marriage. It all boils down to the requirements. Once again, we ask whether the parties were above the age of 18. Did they consent to being married in terms of customary law? Was their marriage negotiated and entered into in accordance with customary law? Because, you know, it happens sometimes that you approach Home Affairs and your marriage is not registered. That's not the end of the story. It's not the end of the day. You still have recourse. You can still approach a court for the registration and recognition of your marriage.
Surely, in Anonymous's call, he says this gentleman was his stepfather. In other words, these are adults. There's no need for any consent. There's no need. They are going to register their marriage. But before you answer that question, we've got another call from KZN, Anonymous too. I don't know why people want to remain anonymous on this issue. Good afternoon and welcome to Rights and Recourse, Anonymous.
Yebo, sabona njani?
Sikhona kunjani?
Ngiyaphila. Mina bengicela ukubuza la ukuthi kwenzeka njani if ukuthi ubukade uhlala nomuntu over for 15 years, right? Nishadile umshado wesiZulu. But inkinga la umshado ningawazange niselu-register kufika la isikhathi ukuthi uyashona. Kwenzeka kanjani lapho?
Siyabonga, thank you very much. We heard that, Anonymous saying, what happens if you have been staying for somebody for over 15 years in a customary marriage and one of the partners passes away and the marriage was never registered? I think earlier I pointed out to the fact that there could be, the male partner might resist having the marriage registered. Can he refuse to have the marriage registered?
Well,
and what are the rights of Anonymous?
Approach the court for relief.
For the relief, yes.
Approach the court for relief, satisfy the court that the requirements for a valid customary marriage were complied with, and the court will then make a determination.
And then request also the court to order the Department of Home Affairs to register the marriage.
Yes.
Can you be more explicit than that? Just a little bit, just put it aside and put it very succinctly.
What she needs to do is to get in touch with the law clinic or the legal aid or get a lawyer. Then she has to approach the court and request the court to give her an order requesting Home Affairs to register the marriage.
Well, there's another call. I don't know whether that call, can we take that call? Yes, we can. Let's listen to that call. We don't know where it comes from. Who are we talking to? Good afternoon. Eric, how are you?
Yeah, tell the guy, man.
You're doing with a guy?
Yeah, man. The push on the guy is she. You want to go Malawi, who protect our and resource highly into their properties. Because the Act doesn't say anything about the right of women to marry two husbands. It only promotes polygamy.
Thank you, Eric. Is that your issue?
Yes.
Eric says the law protects men. There's nowhere where the Act talks about women who want to marry two men.
That's not a practice that's ever been observed in South Africa. That's the response I would give to Eric. The Act recognizes...
You can finalize that when we come back, Mr. Mabaso. Let's take a break. We'll come back. We'll talk to you as soon as we come back after this break.
You can't have a gut feeling about other people's gut feeling.
Ngaba has continued the tradition of passing stories onto the next generation using a platform that offers stories to a far more greater audience.
Zombie no go unless you tell them to go.
This is what the audiences all over the world knew Fela Kuti for.
Join Musam Khalifi on Afro Showbiz every Saturday at 19:30 CAT.
Technology is all around us and is improving lives across Africa, like how young Nigerians are connecting to the internet. There are doctors finding new ways to save lives in Cameroon, and the South African public transport system that is now getting Wi-Fi. We have gadgets, apps and loads more, some of which play a big role in Africa's growth.
A huge part of this African growth is technological innovation. To find out a bit more about social media and technology news from here in Africa and abroad, join Ms. Phumelele Zondi every Sunday at 7:30 p.m. on SABC News.
Welcome back, and quickly, gentlemen, in your concluding remarks, Mr. Malagate, can you respond to what the last caller asked us about the law? Eric.
Unfortunately, the South African law does not recognize polygyny, which is what he's talking about. And frankly, whether that would really work, it would be very difficult. But in terms of the law does allow or recognize polygamous marriages, for as long as there are certain processes that are followed.
Closing remarks, Mr. Mabaso?
What's important for people to know is that if the Department of Home Affairs refuses to recognize and register their customary marriages, they can always approach the courts and satisfy the court that all the requirements were complied with, and the court will give an order directing the Department of Home Affairs to recognize and register the marriage.
Mr. Nameng.
Well, the last caller, if I go back to that issue, maybe wants to make the law, I don't know, in terms of approaching the Constitutional Court and raise issues about discrimination against women and so forth. I don't know if he will succeed with it. But however, coming to the subject, I think generally people need to approach legal aids. I know information is not forthcoming to a lot of people. And like I said earlier, when you don't know your rights, it's like you don't have rights at all. People should be encouraged, and I think the Department of Home Affairs must try to find a way of how to give information to the people so that then this act serves a purpose.
Gentlemen, thank you very much for your time. It's been a very interesting discussion. I never thought it would turn out to be as interesting as this. Members of a traditional community have the right to freely marry and establish and raise their families. Their right to culture includes the right to perform rituals and practice their customs such as lobola. However, these customary law rights must not be inconsistent with the Bill of Rights. For instance, the custom of lobola, and it follows, therefore, that customary marriage must be consistent with the rights to human dignity, equality, and freedom. This has been Right to Recourse. This program is rebroadcast at 10 tonight and at 5 on Monday morning. Thank you to our guests, and from all of us in the studio, good afternoon.